A very good morning to one and all present here, and a hearty welcome to the second day of the two-day National Conference on Companies Act. The first topic for today will be on appointment and qualification of directors and remuneration of managerial personnel. To chair this session, to share his knowledge on these two topics, we have with us a practicing company secretary who is also the ex-deputy ROC, Shri A.M. Sridharan. I request C.A. Babu K. Tevar, Chairman of Bangalore branch, to kindly escort him onto the stage and welcome him with a floral bouquet. I also request Conference Coordinator C.A. Ravi Prasad to join us. Before I hand over the session to the session speaker, a brief background about Shri A.M. Sridharan. Shri A.M. Sridharan is a holder of the bachelor's degree in law. Before he started practicing as a company secretary, he worked as the Deputy Registrar of Companies Karnataka, Bangalore during the years 2007 to 2010. He also worked as a bench officer, Company Law Board, Chennai during the years 1999 to 2007. And he also worked as an assistant official liquidator of the High Court Madras during the years 98 to 99. He has given several guest lectures on topics from incorporation of companies, liabilities of directors, managing directors, partners and managing partners of defaulting companies and firms, court winding up, liquidation, practical and procedural aspects and appearance before the CLB, technical scrutiny of annual reports for the violation of the provision of Companies Act and consequences thereof, voluntary winding up, merger, acquisition and amalgamation, transfer and transmission of shares, and the list, trust me, is never ending. He has also published articles on shareholders, democracy and e-voting, and also on the Companies Act 2013, whether it should be scrapped. With this introduction, I welcome you once again, sir. And over to you.
Good morning, friends. I think we all might have read this new Companies Act 2013 umpteen number of times. Still, we have got a lot of issues on which clarification has to emerge. With that background, I would just like to dwell on the topic which has been given to me: appointment of directors, qualification and managerial remuneration under the 2013 Act. You might have all read definition key managerial personnel, section 251. It says key managerial personnel in relation to a company means the chief executive officer, the managing director or the manager, the company secretary, the whole-time director, chief financial officer and such other officer as may be prescribed. Such other officer is not yet prescribed so far. If you refer to section 203 of the Companies Act, which says certain classes of companies, listed company and certain class of companies which shall have whole-time key managerial personnel, you will find that managing director or chief executive officer or manager, in their absence whole-time director. So a listed company or a public company which has got paid up capital of 10 crore and above need not have whole-time director as well as the managing director, chief executive officer or managing director or manager, in their absence whole-time director. But if a listed company or a public company opted to have these two, whole-time director as well as managing director. Notwithstanding the fact what is contained in section 203, both of them will be regarded as key managerial personnel insofar as section 251 is concerned. So that is the one. Then section 260 deals with the definition of officer in default. So officer who is in default for the purpose of any provision in this act which enacts that any officer of the company who is in default shall be liable to any penalty or punishment by way of imprisonment, fine or otherwise means any of the following officers of the company. In 1956 Act, section 5 uses the word means all of the following officers of the company. So the difference between 1956 and 2013 Act is it says means any of the following officers of a company. You will find Class 1 whole-time director, Class 2 key managerial personnel. Suppose in the company whole-time director is there, other key managerial personnel is also there. Tomorrow if an ROC launches prosecution for any of the defaults committed under the Companies Act, technically an argument could come because the section uses the word any of the following officers of the company. This company has got whole-time director, so other key managerial personnel cannot be touched. They cannot be prosecuted. An argument may come. We have to wait and see how the courts of law will resolve these issues. Then where there is no key managerial personnel, such director or directors as specified by the board in this behalf and who has or have given his or their consent in writing to the board such specification, all the directors if no directors so specified. So if no key managerial personnel is there, any director or director specified by the board and he should have given his consent to act as officer in default. Then any person who under the immediate authority of the board or any key managerial personnel is charged with any responsibility including maintenance, filing or distribution of accounts, records, authorizes, actively participates in or knowingly permits and knowingly fails to take active steps to prevent any default. So any person who has been charged by the board for maintaining the books of accounts, records, authorizes any person, then such person is the officer in default. Then any person in accordance with the advice, whose advice the board is accustomed to act, is also an officer in default. Then every director, this is the most important one, every director in respect of a contravention of any provision of this act who is aware of such contravention by virtue of receipt by him of any proceedings of the board or participation in such proceedings without objecting to the same or where such contravention had taken place with his consent or connivance. So any director who is aware of such contravention is taking place in the company and is a mute participant to the board proceedings who did not object to it, then he will also be considered as officer in default. And the last provision is in respect of any transfer of shares in the company, the share transfer agent RTA will also be considered as officer in default. The only thing is section 260 uses the word any of the following officers. So unlike section 5 under the 1956 Act, so managing director, whole-time director, company secretary, they are together called officer in default. Of course key managerial personnel will cover here because of the word used any officer in any of the following. So at the time of issuing show cause notice, the ROC office has to be exercise their power very carefully, who has to be charged with. Then filing of forms. Obviously New Companies Act has been notified on 1/4/2014, especially section 203 whole-time key managerial personnel. An existing company which has got whole-time key managerial personnel and who has got some residuary period, whether he has to file certain forms. Insofar as MD whole-time director is concerned, certainly not, because for him the company might have already filed Form 25C and Form 23 under the old Companies Act, as the case may be. You are required to file only in respect of Chief Executive Officer and Chief Financial Officer because they are the whole-time key managerial personnel under section 203, the Form MR1 under section 203 and DIR 12 under section 170 subsection 2 and MGT 14 under section 117 of the New Companies Act 2013. A company is required to file only for these two persons. Rest of the persons, MD, company secretary, they need whole-time director, they need not file because they would have filed already Form 25C or Form 23. Then definition, Board of Directors, Board, same definition. Section 234, Director means a director appointed to the board of the company. Section 210, Board of Directors or board in relation to a company means the collective body of directors. So individually a person is known as director, collectively known as board of directors. Then managing director and manager. See, Section 253 says manager means an individual who, subject to the superintendent's control, direction of the board of directors, has the management of the whole or substantially the whole of the affairs of a company and includes the director. So manager also includes the director or any other person occupying the position of a manager by whatever name called, whether under a contract of service or not. Section 254 defines managing director. Managing director means a director who, by virtue of the articles of the company or an agreement with the company or a resolution passed in general meeting or by its board of directors, he is entrusted with substantial powers of management of the affairs of the company and includes the director occupying the position of managing director by whatever name called. When I was bench officer of the company law board, interestingly I had to go through one of the old files. In one company at that point of time prior to 1988, because 1988 only the section 269 was amended by the Companies Amendment Act 1988. Prior to that, one of the company's managing director was there, in which certain complaints have gone against him. The ministry has given a direction that managing director should vacate from the office of the director prior to 1988. And the person, somehow the news has reached the company, even prior to the government direction reaching that company, that particular person resigned from the board. And with all the same powers, he has been once again designated as president in that company. An interesting discussion in that file I saw. So, when a person could be called as a managing director? To call a person as a managing director, a person should be basically a director. If he is having substantial powers of management, that's a different matter. Basically, he should be a director. If he is not a director, an individual, if he enjoys substantial powers of management, then he could be called as a manager. So, basic distinction in the board, not in the board. But having in the board a person, when he could be called as a manager, because managing director says, managing director means a director who by virtue of the articles, these four conditions must be there, any of these conditions, either by the articles of the company or an agreement with the company or a resolution passed in general meeting or by its board of directors, he should be designated, appointed as managing director. By virtue of these four clauses, if these four are absent, a director, in spite of, because of the absence of these four provisions, four situations, if a director enjoys substantial powers of management, notwithstanding that he being in the board of the director, he should be called only as a manager and not as a managing director. And kindly see, section 253, it ends whether under a contract of service or not. The more emphasis on not having the contract there, because if he had been having a contract, then it will be covering under an agreement with the company. By virtue of an agreement with the company, a director who enjoys substantial powers of management, he will be called as a managing director. So, in the absence of these four situations, if a director enjoys substantial powers of management or whole of the powers of the management, then he could be only called as a manager and not as a managing director. Then, whole-time director, CEO, CFO. Section 294 says, whole-time director includes the director and the whole-time employment of the company. In this place, though the section uses the word includes, according to the interpretation of statutes, in this particular situation, it has to be read as means only. Whole-time director means a director in the whole-time employment of the company. You might have read under 1956 Act, the erstwhile Department of Companies has issued various circulars, because that time the companies was having the practice, a person was not in the board, designating them as executive director. Ministry has issued advice to the companies, don't use such a designation if that particular person was not in the board, because that will make a misrepresentation to the public, so saying that that person is one among the board. So naturally, whole-time director here include should be read as means. Whole-time director means a director in the whole-time employment of the company. Section 218, Chief Executive Officer means an officer of a company who has been designated by it. So Chief Executive Officer, if a person who is not on the board, if he enjoys substantial powers of management, if he is not designated as Chief Executive Officer, then he should be regarded as manager only because of that decision. To regard one person as a Chief Executive Officer, he must be designated as such. In the absence of designation, if such person enjoys substantial powers of management, then that person should be regarded as manager under the Companies Act. Section 219, Chief Financial Officer. Chief Financial Officer means a person appointed as Chief Financial Officer of the company. I am still unable to understand why the Chief Executive Officer, the Act uses the word any person who has been designated as such, whereas 219, Chief Financial Officer means a person appointed as Chief Financial Officer of the company. So, this is basically the definition for key managerial personnel. Then, number of directors. You know that section 149 deals with the 2013 Act deals with the number of directors. For a public company, as usual under the old Act, a minimum of 3 directors is required. Private company, a minimum of 2 directors. One-person company, a minimum of 1 director is required. In the same section, it says there can be maximum number of 15 directors instead of 12 directors under the old Act. Under the old Act, beyond 12 directors, one has to approach the central government for permission. Now, for increasing beyond 15 directors, a special resolution is required to be passed by the central government. There is no need to approach the, special resolution is required to be passed by the company in general meeting, and there is no need to go to the central government. Then, if you see broadly, I believe the kinds of director is 2 kinds, rotational director and non-rotational directors. Among these, you can have classes of directors. This kinds is a very broad term, like 2 kinds of shares, equity shares and preference shares. Below that, you will get classes of shares, equity shares you will get class of shares, A class equity share, B class equity shares with the differential voting right as to dividend and voting. Likewise, director also, kinds of directors you can classify it as rotational and non-rotational. And when it comes to classes of directors, basically now there are 4 classes. You can categorize them into 4 classes. Resident director, woman director, independent director, small shareholders director. Resident director section 149(3) speaks, every company shall have at least 1 director who has stayed in India for a total period of not less than 182 days in the previous calendar year. So, every company must have 1 resident director, and such person should have stayed in India for not less than 182 days in the previous calendar year, not in the current calendar year. And Ministry has given a circular clarifying this previous calendar year 25 or 2014. In fact, this clarification adds to more confusion than clarifying it. It says existing companies shall have resident director who have stayed in India exceeding 130 days during the year 2014. I believe that instead of during the year 2014, it should have been during the year 2013, because in the circular Ministry says this Act has been notified, this particular section has been notified on 1/4/2014. So, for the calendar year 2014, that is only 9 months, 1/4/2014 to 31/12/2014. Then, pro rata 136 days a person should have stayed. But while giving the clarification, Ministry said he should have stayed 136 days during the year 2014. Obviously, I feel it's wrong, it must be 2013. Then, companies incorporated between 1/4/2014 and 39/2014 shall have resident director at the time of incorporation or within 6 months from the date of their incorporation. Companies incorporated after 39/2014 shall have resident director at the time of incorporation itself. So, this is the clarification given by the Ministry. Then, woman director. Section 149 subsection 1 further says, provided further, such a class of companies as may be prescribed shall have at least 1 woman director. Existing companies, 149 subsection 2 says, they shall have to comply with this, having at least 1 woman director on the board within a year of notification of this particular section Act. Then Rule 3 of the Companies Appointment and Qualification of Directors Rules 2014 says, which are the classes of companies, they shall have the woman director. It says every listed company, every other public company having paid up capital of 100 crore rupees or more, or turnover of rupees 300 crore or more, they shall have a woman director. And proviso of that particular rule says, company incorporated under the Act shall comply with the provisions within 6 months from the date of incorporation. Insofar as the existing companies are concerned, subsection 2 says they shall have to comply within a year. Existing companies, the companies which exist on the date of notification of this section, that is 1/4/2014, existing companies shall have to comply within a year. Companies which are incorporated under the new act, they shall have to comply with the provisions within 6 months from the date of incorporation. If any vacancy arises, it says it shall have to be filled up as quickly as possible, but not later than the next board meeting or 3 months, whichever is later. So that's what the rule says. Then woman director in listed companies, SEBI-wide circular by which it brought certain amendments to clause 49 of the listing agreement, which has been notified on 15/9/2014. SEBI originally issued in April 2014 amending the clause 49 of the listing agreement. In that clause 49 of the listing agreement, woman director, it does not give any time limit period. So now SEBI has come out with an amendment to that original circular issued in April 2014 on 15/9/2014. By the circular, SEBI says the appointment of woman director as provided in clause 49(2)(a) 1 shall be applicable with effect from 1/4/2015. So the listed companies are now given, they can have the woman director on the board with effect from 1/4/2015. So more or less the period which has been said in the company subsection 2 of section 149, that has been given to listed companies also by the SEBI. And if you see that that particular circular issued on 15/9/2014, SEBI has exempted certain listed companies from compliance with the clause 49 itself. The circular which has been originally issued in April 2014, it was made to be applicable to all listed companies with effect from 1/10/2014, 1st October 2014. Because of various representations made to the SEBI, SEBI has amended on 15/9/2014, by which amendment SEBI has exempted certain companies from complying with the clause 49. So naturally these companies, though they are exempted by the SEBI under clause 49, they will have to still comply with the provisions of the Companies Act 2013 insofar as the woman director, independent director, related party transactions and others are concerned, which are covered under the clause 49. So what are the listed companies exempted by the SEBI? Companies having paid up equity share capital not exceeding rupees 10 crore and net worth not exceeding 25 crore. So it talks about cumulative condition, not exceeding 10 crore paid up capital and net worth not exceeding 25 crore as on the last day of the previous financial year. These companies are exempted. But if these companies subsequently cross this threshold limit, then they shall have to comply with the clause 49 within 6 months of crossing that threshold limit. Then companies whose equity shares is listed exclusively on the SME and SME ITP platforms, irrespective of their paid up capital and turnover, they are exempted wholly from the clause 49. But these companies have to comply with still Companies Act 2013. Then classes of directors. First let us see the independent directors. Section 149 speaks about who is an independent director. It says independent director means a director other than a managing director, full-time director and nominee director. So nominee director is a director appointed by the institutions, financial institutions, to the board of the company. Other than these three, the rest of them can be regarded as independent directors. Section 149 subsection 4 speaks about who should have the independent director. Every listed public company shall have at least 1/3 of total number of directors as independent directors, and the central government may prescribe the minimum number of independent directors in case of any class or classes of public companies. Then Rule 4 lays out what are all the classes of companies shall have the independent directors. So 149(4) section itself says every listed company. So listed company shall have 1/3 of the total number of directors as the independent directors. Other classes of companies is prescribed by the rules. Rule 4 specifies which are the companies should have the independent directors. It says public companies having paid up share capital of rupees 10 crore or more, or public companies having turnover of 100 crore rupees or more, or public companies which have in aggregate outstanding loans, debentures, deposits exceeding 50 crore rupees or more, okay, shall have at least 2 independent directors. So listed companies, irrespective of their paid up capital, irrespective of their turnover, irrespective of their deposits or outstanding loans, they shall have to 1/3 of the total number of directors as independent directors. Insofar as other public companies are there, if they satisfy this criteria, any one of this criteria, then shall have 2 independent directors. Then listed companies, SEBI wide this circular, amended circular 15/9/2014, amended clause 49(2)(a) slightly, composition of the board. It says, SEBI says optimum combination of executive and non-executive directors with at least one woman director and not less than 50% of the board of directors comprising non-executive director. It speaks about optimum combination, how a board should be, how a board should consist of the people. With at least one woman director, this one woman director, it says it has to be implemented from 1/4/2015. Okay. Then 50% non-executive and 50% comprising executive director. Then it also says where the chairman of the board is a non-executive director, non-executive chairman, then it is more or less on the lines of the Companies Act. 1/3 of the board should comprise independent director. In case the chairman is the regular executive chairman, then half of the board should be the independent directors. Half of the board should be the independent director. A company has non-executive chairman as non-executive person as a chairman, but if he is a related person to the board, then also it says the board should comprise of half of the board should be the independent director. So that is the one. Independent director, rule 4 talks about higher composition. It says provided that in case a company is covered under this rule, is required to appoint a higher number of independent directors due to composition of its audit committee, such higher number of independent directors shall be applicable to it. Section 177(2) of the Companies Act 2013 talks about composition of audit committee. It says a company shall have audit committee consisting a minimum of 3 directors. Majority of them shall be independent directors. But SEBI under the clause 49, it words slightly differently. An audit committee shall consist of 3 directors, minimum of 3 directors, and 2/3 of them will be the independent directors. Act says majority of them should be the independent director. So as long as you have only 3 directors in the audit committee, no problem, because majority of the independent directors will also be 2, 2/3 of the audit committee will also be 2. The moment you go for a higher composition of the audit committee, suppose there are 5 directors or 6 directors in the audit committee, then according to the Companies Act it will vary. So if it is unlisted company, then you will have to go by the Companies Act, see to that whether the audit committee higher number of independent requests are required, then you shall have to have that person in the board. If you are a listed company, go by the SEBI rules. If you have got a higher number of audit committee consisting of more than 3 persons, then 2/3 of them shall be the independent directors. Then independent directors qualifications. Section 149 subsection 6 speaks about what are all the qualifications a person should have to become an independent director. These qualifications presupposes unless a person satisfies these conditions, he cannot become an independent director on the board of the company. So this is prerequisite. If you see that originally in 2004 when the SEBI issued clause 49 listing agreement, certain conditions were there incorporated for independent directors, and those conditions have been brought into Companies Act with a slight modification under the 2013 Act under section 149 subsection 6, and these conditions now SEBI has taken once again in this amendment issued on 15/9/2014. That's only the only difference where it causes confusion is independent directors. One of the qualification under the clause 49 it says, who neither by himself nor any of his relative is a material supplier, service provider or customer or lessor or lessee of the company. SEBI says the independent director shall not be the material supplier. Material supplier in the sense here raw material supplier, okay, not in the materiality sense, having some figure, raw material supplier, okay, or some good supplier, material supplier, service provider. He should not be a service provider, he should not be a customer, okay, he should not be a customer, or a lessee of the company. He shall not do anything, even he cannot do even one piece transaction with the company prior to becoming the independent director. And another class, if you seek amended class 49 2B1C, originally when it was notified in April 2014, it was the SEBI has stated, apart from receiving director's remuneration, the independent director, the person has or had no pecuniary relationship with the company, its holding subsidiary or associate company, or their promoters or directors during the two immediately preceding financial years or during the current financial year. But in this amendment issued on 15/9/2014, SEBI has inserted the word no material pecuniary relationship. So this material pecuniary relationship and the class 5 earlier, who should not be a supplier, raw material supplier or service provider or customer, they are not going smoothly, they are not complementary to each other. That is because originally in class 5, the SEBI has added the words, the person independent directors should not be a material supplier, service provider or customer or lessee of the company, which may affect the independence of the director. He can be a material provider or he can be a supplier, he can be a customer, but that should not affect his independence. That was the original class 49 issued, which was standing prior to April 2014. When the SEBI amended in April 2014, it has omitted the words which may affect the independence of the director. Simultaneously, in remuneration also, it has omitted the word material, because when you say you can't be a supplier for a single rupee, naturally you cannot have, the SEBI has to say that no pecuniary relationship. But now in September 2014, when they inserted the word no material pecuniary relationship, they failed to insert the words once again, which may affect the independence of the director in this particular class 5. So that is because of this confusion is there. Now it may be rectified at any point of time. So as on date, so an independent director, prior to becoming an independent director, he should not have had any major pecuniary relationship other than the drawing of remuneration from the company. Then independent director's tenure which has been, as far as the listed company, tenure which has been specified in the April 2000 notification, now circular issued by the SEBI has been now made in line with the Companies Act by the circular issued in 15/9/2014. SEBI now goes by the 149(10) and 149 section 10, 149 subsection 11 of the Companies Act. According to these sections, an independent director shall have a maximum tenure of 5 years. A person who has been appointed as independent director for a period of 5 years, he can be appointed for a second term of 5 years by passing a special resolution in the company's general meeting. And 149(11) also says, for the purpose of calculation of this tenure, any person who has been independent director of the company at the commencement of this act, that particular tenure shall not be taken into account. And it also says, company shall have to comply with the provisions of this particular section within a year of this notification. So because of this, Ministry has issued a circular clarification by circular number 14 of Companies Act, circular number 14. In the circular number 14, Ministry has clarified, because the Act says the existing tenure shall not be counted, the existing tenure of the independent director who are at the commencement of this Act shall not be counted, and the companies shall also comply with this provision within a year of this notification. Independent directors have to be appointed under this Act. So because of this circular, you might have seen many companies in their annual general meeting, they have appointed the independent directors for a period of 5 years. Ministry has also clarified in the circular, if a person has been appointed as an independent director for a period of 3 years, right, and whether he can be appointed for the rest of the 8 years, the 3 years plus 7 years, 7 years by way of one more appointment, one more tenure. Ministry has said no, because the section speaks in terms of tenures, 2 tenures. So whether you appoint it for 5 years or less than 5 years, it doesn't matter. An independent director cannot be appointed more than 2 years, more than 2 terms of 5 years, more than 2 tenures. So that is the clarification given by the ministry. And after the expiry of these 2 tenures, there should be a gap of 3 years. There should be a leave of 3 years for the same person to be appointed as independent director. And thus, during the 3-year gap, the independent director shall not have any relationship with the company. So that is the section 149, subsection 10 and subsection 11. Then, independent directors vacancy. Clause 49(2)(d)(4), SEBI says, under the listing agreement, an independent director who resigns or received from the board of the company shall be replaced by a new independent director at the earliest, but not later than the immediate next board meeting or 3 months from the date of such vacancy, whichever is later. Then Rule 4 issued by the ministry under company's appointment of directors rules. Further proviso, Rule 4, Clause 1 further proviso says, provided that any intermittent vacancy of an independent director shall be filled up by the board at the earliest, but not later than immediate next board meeting or 3 months from the date of such vacancy, whichever is earlier. So almost the rule issued by the SEBI, stance taken by the SEBI, and the rule issued by the ministry almost same. The only difference is the SEBI rule is worded in passive voice and the ministry rule is worded in active voice. And you go to under the Companies Act itself, there is a Schedule 4. Schedule 4 also speaks about the independent director, role of independent director, conduct of independent director, duties, and it also speaks about vacancy. There is a contradiction there in the Schedule 4. Schedule 4, para 4, subpara 2 says, an independent director who resigns or is removed from the board of the company shall be replaced by a new independent director within a period of not more than 182 days from the date of such resignation or removal, as the case may be. So there is a contradiction between the rule and the schedule. The ministry has to now clarify this, be that as it may be. What substance is an independent director vacancy if it is cast? So it has to be filled up by the board. His vacancy has to be filled up by the board not later than next board meeting or 3 months, whichever is later. A question arises, suppose if an independent director who has been appointed for a period of 5 years, after 6 months he resigns, whether the board can appoint him in that casual vacancy, whether it should be regarded as a casual vacancy first. If it is regarded as a casual vacancy, if he is appointed in that person, otherwise he is fulfilling the qualifications of the independent director, another person is appointed in that casual vacancy, whether he can hold the rest of the 4.5 years, right, without meeting the general body meeting, whether it can be treated as a casual vacancy. It cannot be treated as a casual vacancy because these clarifications does not word on the lines of, have not been worded on the lines of old section 262 or the new section or the new section 161 subsection 4. Under the new Companies Act section 161 subsection 4 also is equivalent to the section 262 of the old Act 1956. The old Act 1956 says, if a person is appointed in a casual vacancy, any casual vacancy arises in the board of director, the board can fill that casual vacancy and the person who fills up that casual vacancy will occupy the office till that time the original director would have occupied the office. That is 262. Whether that analogy can be applied to the office of the independent director, in my opinion it cannot be applied. The rule SEBI 49 listing agreement and also the rule 4 says, it shall have to be filled up by the board within next immediate board meeting or next to 3 months, whichever is later, but nowhere it says it has to be regarded as a casual vacancy. Only thing, you can appoint him in the board only as an additional director, not in a casual vacancy. Then as quickly as possible, you will have to go to the general body and get the approval of the general body, and such an approval will be for a period of 5 years, not for 4.5 years. Understand? Am I clear on it? So, an independent director, if he resigns from the office of a director, independent director, any other person can be appointed by the board, right? But that vacancy shall not be regarded as casual vacancy. That vacancy shall not be regarded as casual vacancy, because these rules are not worded on the lines of Old Act section 262, which deals with the casual vacancy, or section 161 subsection 4 of the New Act 2013, that cannot be regarded as casual vacancy. So once you are not regarding it as casual vacancy, the person filled up by the board has to be construed as a person newly appointed as independent director. He could be appointed as additional director in the board meeting. Then immediately you convene the general meeting as quickly as possible. Go get the approval of the general body for a period of 5 years approval for that particular person from the date of appointment to the board. So simple conclusion is that vacancy cannot be treated as a casual vacancy. Then independent directors, how they should be appointed. Section 152, read with section 152, section 152 and subsection 2, and schedule 4, para 4, subpara 2 clarifies this, how they should be appointed. It says section 150 subsection 2 says, subject to the provisions of section 152 subsection 2, an independent director shall be appointed in the general meeting. Then 152 subsection 2 says, save as otherwise provided in any other provision of this act, all the directors shall have to be appointed in general meeting. So section 150 subsection 2 says, an appointment of independent director shall have to be approved in the general meeting as per section 152 subsection 2. Section 152 subsection 2 says, save as otherwise provided in this act, all directors have to be appointed at the general meeting. Okay. So appointment is one thing where it is done at the first instance. Approval is something you go and get to the general body. The board has already done this, kindly approve this appointment. Once again, the wording is very confusing in this act, section 150 subsection 2 and section 152 subsection 2. And once again, if you go to schedule 4 para 4 subsection 2 also, there you will find the appointment of an independent director shall have to be approved in the general meeting. So all these things together gives a conclusion. An independent director can also be appointed as additional director in the board meeting, provided he fulfills all the qualifications relating to the independent director. So once he is appointed as additional director, then immediately you have to go to the general body meeting, convene a general body meeting, and get his appointment approved by the general body. So that is the sum and substance of section 150 subsection 2, 152 and subsection 2. So next question, whether independent directors can be appointed as additional directors. Obviously he can be appointed as additional director. Then in the next general meeting their appointment can be approved. Then whether independent directors can be appointed in a casual vacancy. They can be appointed in a vacancy arising out of the resignation of an independent director, but as we have seen earlier, that cannot be treated as a casual vacancy. Otherwise, that lead to a situation, the replaced director will be occupying the office of the remainder period without meeting the general body. So that is not the intention of the act. So an independent director can be appointed in a vacancy caused by a resignation, but that vacancy cannot be considered as a casual vacancy. That is the one. Whether independent directors can be replaced by alternate directors, obviously section 161 subsection 2 proviso says they can be done. If a director is not present for a period not less than 3 months, then he can be replaced by a director. That particular section 161 subsection 2 also says an independent director can be replaced by an alternate independent director, provided he should also fulfill the qualifications of the independent director. The moment the original independent director returns to the office, the alternate director deemed to have vacated the office. So that is the provisions of section 161 subsection 2. Then another class of director we come across, as far as the number of companies concerned independent director, SEBI has stated an independent director cannot have office more than 7 listed companies. Suppose an independent director is a old-time director in a company, he cannot be independent director in other 3 listed companies. That is what it says SEBI. I mean it's not very clear. An independent director cannot be an independent director more than 7 listed companies. That is the only thing. Then small shareholders director. Section 151 deals with the small shareholders director. For this purpose, small shareholder is defined as a person having shares worth not exceeding 20,000 rupees. Rule 7 of the Company's Appointment and Qualification of Directors Rules 2014 says, a listed company upon notice of not less than 1,000 small shareholders or 1/10 of the total number of small shareholders, such shareholders cannot be read as 1,000 small shareholders, it should be read as 1/10 of the total number of small shareholders, whichever is lower, have a small shareholders director elected by the small shareholders. A listed company on its own can have small shareholder director, or upon notice of 1,000 small shareholders or 1/10 of the total number of such small shareholders, they shall have to have independent small shareholders directors, and the procedure is prescribed in this Rule 7. Notice has to be given not less than 14 days with the company, then the company has to circulate along with the notice of the general meeting subsequently. Then if he is selected, then he will become the small shareholders director. The rule also says, if the small shareholder director, if he otherwise fulfills the qualification of the independent director, then he can also be regarded as independent director. The only difference is the small shareholder director tenure is limited for a period of 3 years. 3 years. Whereas independent director tenure is for a maximum period of 5 years. If for any reason, if the small shareholder director who otherwise fulfills the qualification of the independent director, if he is treated as an independent director by the company, whether he can occupy the office for 5 years? No, because basically he is a small shareholder director, he has to vacate the office after 3 years. So he is not liable to retire by rotation. The small shareholder director is not liable to retire by rotation. The fundamental difference between the independent director and the small shareholder director, independent director, for the purpose of calculating the number of directors liable to retire by rotation, the number of directors have to be excluded from the total number of directors. For example, if a company has got 15 directors as total number of directors, 3 of them are independent directors. For the purpose of calculating the directors who are liable to retire by rotation, the total number of directors have to be taken into account is 12. 15 minus 3. You will have to exclude the independent director totally. But if a small shareholder director who otherwise qualifies satisfies the qualifications of independent director is regarded as a small shareholder director by a company, whether such person can be excluded from the total number of director. In my opinion, he cannot be excluded because he is basically a small shareholder director only. However, he is not liable to retire by rotation. So among that 15, you minus 3 independent directors, 12 will be there, and if in any 12, if any small shareholder director is there, you will have to reckon him under the non-rotational director. Don't take it as rotational director. So that is what the rule says. In any case, he cannot occupy the office more than 3 years. Then, appointment of directors. If you had read section 254, 255, 256 of the Companies Act 1956, one interesting situation is there. In fact, I would have read the 3 sections not less than 50 times. If you read section 256 of the 1956 Act, which is analogous provision under the new act is 1 section 152 subsection 6 class C. It starts with the word at the first annual general meeting of a public company held next after the date of the general meeting at which the first directors are appointed. This phrase conveys at the first annual general meeting of the public company held next after the date of the general meeting at which the first directors are appointed. This throws a situation there could be a general meeting prior to the first annual general meeting. If you recollect section 254, section 255, section 256 of 1956 Act, 254 says, in default of and subject to the regulations of the articles of a company, the subscribers to the memorandum who are individuals are deemed to be the directors of the company until the directors are appointed in accordance with section 255, that is 254. So, what does it mean? In the articles of a company, if the subscribers have not chosen to name the first directors in the articles of the company, then the subscribers to the memorandum who are individuals, they are deemed to be the directors, and the deemed directors will occupy the office till the general meeting is convened in accordance with the section 255. 256 says, at the first annual general meeting of a public company held next after the date of the general meeting at which the first directors are appointed, which means in an articles of association, if the subscribers have chosen not to name the first directors, then the subscribers who are the individuals, they become the deemed directors, and those deemed directors cannot occupy the office till the first annual general meeting. The company has to convene one general meeting prior to first annual general meeting, in which the deemed directors shall have to be replaced by the shareholders by appointing the directors. So, if you are naming in the articles directors, they are first directors. If you don't name in the articles, subscribers are the deemed directors, then in the general meeting, the shareholders have to elect first directors, and that general meeting has to be held before the first annual general meeting. So, this is what the combined reading of section 254, 255, section 256 of the 1956 Act will throw away. Then 255 on its own creates that when the subscribers to the memorandum are deemed as directors, 255 says, two-thirds of the deemed directors are liable to retire by rotation, and class B says, and those directors shall have to be appointed in the general meeting. 255, if you carefully say it has got class A and class B, okay. Two-thirds of the directors are liable to retire by rotation, and those directors have to be appointed in the general meeting, okay. Then subsection 2 also says, the remaining directors of such company, in default of and subject to regulations in the articles of the company, they shall also have to be appointed in the general meeting. So, what does it mean? In a company, in an articles of association, if the first directors are not named, the subscribers who are the first directors, they have to be retired in one general meeting which is conducted before the first annual general meeting. Out of these first directors, two-thirds are liable to retire by rotation, and they will have to be appointed. If the article is also silent on the rotation of the directors, right, then the remaining one-third of the deemed directors shall also have to retire in that particular general meeting, and they shall have to be reappointed. This is one situation, and on the other situation, 255 also creates a legal proposition. It creates a legal proposition in case if the first directors are named in the articles, out of that, two directors are liable to retire by rotation, and out of that two-third, one-third shall have to retire in the first annual general meeting which is conducted in accordance with the section 256. So, this is what the combined reading of 254, 255, 256 will emerge, and the 254, 255, 256 is now consolidated into a single section 152. So, this is the by and large section 152. Then I have already dealt with this. 152 subsection 6A, and one more thing, 255 also starts with the word 1956, unless the articles provide for the retirement of all directors at every annual general meeting. 255 starts with the word unless the articles provides for the retirement of all directors at every annual general meeting. Suppose if the article provides for retirement of all directors at every annual general meeting, whether the subscribers name in the whether subscribers name the first directors in the article or not, it is immaterial. Even if they name it, all of them have to be retire in the first annual general meeting and they have to be appointed. So, if the article says all the directors have to retire in every annual general meeting, then 256 will have no application at all, because 256 discusses 1/3 shall have to retire and 1/3 shall have to be reappointed. So, when the 255 says your article specifies all the directors have to retire at every annual general meeting, then 256 has no application at all. So, that is a simple meaning of section 254, 255 and 256. And unfortunately, this 152 new act is slightly worded wrongly. Kindly see this. Section 152 subsection 1, where no 152(1) is analogous to section 254 of the 1956 Act. Section 152 subsection 1, where no provision is made in the articles of a company for the appointment of first director, the subscribers to the memorandum who are individuals shall be deemed to be the first directors. It's very wrongly worded. Under the 1956 Act, the subscribers to the memorandum, in the absence of naming the directors in the articles, they are deemed directors. They are not the first directors. Whereas the new Act wrongly regarded them as first director. Once again, shall be deemed to be the first directors of the company until the first directors are duly appointed. So when you already deemed them as first director, where is the question of appointing them once again as first director? So there is no, there is an incompatibility in that section 152. It may go through certain amendment very soon. Then section 161 deals with the appointment of additional directors, alternate directors, nominee directors and directors appointed in casual vacancy, which you have already dealt with. Only thing, additional director, it says a person who has not been elected in the annual general meeting, he cannot be appointed as an additional director. There is no backdoor entry for appointment of a person who has been appointed, who has been defeated in the annual general meeting. So that is 161. Then directors qualification, 164 deals and 167 deals with the vacation of office of director. The difference between the old act and new act is, under 167, the new act says if a person suffers any disqualification under section 164 of the act, then that will be one of the ground for vacation of the office of director under section 167. So 164 speaks about disqualification. 167 speaks about vacation of office. 167, the first clause says, if a person suffers any of the disqualification enumerated in section 164, then he is vacating the office of the director. So that is the first condition in 167. The only contradiction between 164 and 167 is, under 164, one of the clauses says, if a person is convicted of an offence of moral turpitude or otherwise and sentenced to imprisonment for not less than 5 years, right, that is one of the disqualification for becoming a director under section 164. And later subsection says, if a person has filed an appeal on that sentence, then this disqualification will not operate. That is section 164. And 167, if you go, because 167, the first clause says, the moment you suffer one of the disqualification, any of the disqualification under 164, you are vacating the office of the director, right? 167 itself, one of the clauses provides, if a person is convicted for a period of, convicted on moral turpitude or otherwise, for a period of not less than 5 years, then he shall vacate the office. There the proviso says, provided he will vacate the office even if he files an appeal also. So, 164 you say that if you file an appeal, it is not a disqualification. 167 says, even if you file an appeal, it is a vacation of office, one of the grounds for vacation of office. And 167 also speaks about whatever the disqualification you suffer under 164, that is one of the ground for vacation of office. So there is a contradiction in 167. We will soon have amendment in this particular section 167. Then, so with this appointment of directors by and large over. So 152 subsection 2 says, save as otherwise provided, every director has to be appointed at the general meeting. That is the sum and substance ultimately. Then you know that a deposit of 1 lakh has to be paid by the companies and directors who contest the office of director. In case if they don't get 25% of the votes polled, the money has to be forfeited. That is for the companies with the share capital, the section says. The ministry has last week or 2 weeks before issued a clarification in so far as the section 8 companies are concerned. Since the Companies Act does not talk about the forfeiture of the deposit, it is for the board to decide. If the board decides to forfeit, they can forfeit the deposit, or if the board decides to refund, it can refund. That is a clarification issued by the ministry just 2 weeks before. Then now let me come to this managerial remuneration. Managerial personnel, you say that managerial personnel is defined under part 1 of schedule 5. For the purpose of part 1 of schedule 5, it says a managing director, full-time director, manager, they are regarded as managerial personnel. Key managerial personnel, we have seen section 2 subsection 51. So full-time chief executive officer, managing director or manager, full-time director, chief financial officer, company secretary, they are key managerial personnel. Any other person prescribed? So far no person is prescribed. Whole-time key managerial personnel, section 203 speaks about chief managing director, chief executive officer or managing director or manager. In their absence, full-time director, then chief financial officer, company secretary. These are the whole-time key managerial personnel. But when it comes to payment of remuneration to managerial personnel, these 3 persons only will have to be considered. That is managing director, full-time director or manager under the Companies Act, chief executive officer and the chief financial officer, they are not regarded as managerial personnel insofar as the payment of remuneration is concerned. Then section 203 speaks about every listed company and such class of companies shall have whole-time key managerial personnel. Rule 8 of the Companies Appointment and Remuneration of Managerial Personnel Rules 2014 says, every listed company and every public company having a paid-up capital of 10 crore rupees or more shall have whole-time key managerial personnel. Then, a private company simpliciter need not have whole-time key managerial personnel, but however, it opts to have a whole-time key managerial personnel. Only thing, it has to file that DIR 12 and the MGT 14. It need not file MR1. It need not file MR1. If a private company opts to have a whole-time key managerial personnel, it need not have, but if it opts to have, it has to file only the MGT 14 and DIR 12 under the relevant sections of the Companies Act. Right? 196 subsection 4 speaks about the appointment of a managerial personnel in a company. 196 subsection 4 says, an appointment of a managing director or whole-time director or manager shall have to be done in the board meeting. His remuneration shall have to be fixed in the board meeting. And once again it says, it further goes on to say that he shall also to be appointed at the general meeting and remuneration also to be fixed in the general meeting. The 196, section 196 does not make any discrimination between private company and public company. So 196.4, it applies to private company as well. So it's a deviation from the 1956 Act. Under the 1956 Act, for appointment of managerial personnel, you are purely guided by your articles of association. If your articles of association says the appointment of a managerial personnel has to be approved in the general meeting, you will have to go to the general meeting. If your article vests that power with the board of directors, then it is suffice, you appoint into the board itself, you need not go to general meeting. But this section 196.4 speaks, which applies to both private as well as public companies. You will have to get appointed in the board meeting, remuneration fixed in the board meeting, and also once again appointed in the general meeting, and also it should be in fact approved in the general meeting, not appointed, but section is wrongly worded. Appointed in the general meeting and remuneration also approved in the general meeting. Because of this, some representations have been made to the ministry Ministry has issued a draft exemption notification for the private companies. That notification has not yet been officially issued till date. It is still pending before the Parliament. In the draft exemption notification, Ministry has exempted the section 196(4). And there the danger lies. If you exempt the section 196(4) for the private companies as a whole, then private companies where they will appoint the managing director or managerial personnel. Your articles may provide for it, but apart from 196(4), you have got some other section which also deals with the appointment of these personnel. You remember that under section 117 of the new Act 2013, such of the resolutions are passed in the board meeting in accordance with section 179 of the Companies Act. They will have to be filed with the ROC, Registrar of Companies. Okay. 179. One of the clauses, subsection one of the clauses deals with such other matters as may be specified. Such other matter as may be specified, in the rules it is given appointment of key managerial personnel. 179 deals with the powers of the board. What are all the transactions to be done in the powers of the board? One of the clauses 179, if my memory is right, subsection 3 says such other matter as may be specified. Such other matter as may be specified is specified in the rules. In the rules, appointment of key managerial personnel, once to take note of the appointment one step below the key managerial personnel. So key managerial personnel invariably they have to be appointed only in the board. It is under the 179 powers of the board. So even if a private limited company is exempted under section 196(4), a private company still have to appoint the managerial personnel under the powers of the board under section 179 read with that particular board in a board meeting. Once you appoint in that board meeting, 117 will apply. You will have to file MGT 14 with the Registrar of Companies. So a private company also should file MGT 14 with the Registrar of Companies because of 117 read with 179 read with the relevant rules. And under section 170 subsection 2, appointment of every director, appointment of every key managerial personnel and the changes therein shall also have to be intimated to the Registrar of Companies, and that has to be done in day or 12. So a private company has to file MGT 14 day or 12 with the Registrar of Companies insofar as this key managerial personnel is concerned. A public company, listed company is concerned, they will have to file in addition MR1 also in addition to these two forms. And that particular return has to be filed within 60 days of the appointment, MR1. Under the old Act, Form 25C 90 days was given. Now the time limit is reduced to 60 days. Then managerial remuneration is most important. Section 197 subsection 1, the total managerial remuneration payable by a public company to its directors, including managing director and whole-time director and its manager, in respect of in any financial year shall not exceed 11%. So 197 subsection 1 itself starts with the wording total managerial remuneration payable by a public company. Okay. There have been debates during some time after the notification of this 2013 Act. 197 subsection 3 contains a wording like this: notwithstanding anything contained in subsection 1 and 2, but subject to the provisions of Schedule 5, a company may pay remuneration to the managerial personnel in accordance with the provisions of Schedule 5, and if it exceeds Schedule 5 with the approval of the central government. So certain interpretations have come. 197 subsection 3 applies to private limited companies also. Okay. So the section 197(3) uses two legal terms, notwithstanding 1 and 2, subsection 1 and 2, subject to the provisions of Schedule 5. So notwithstanding 1 and 2 means the provisions of subsection 3 overrules notwithstanding 1 and 2. It overrules subsection 1 and 2. Okay. But subject to provisions of Schedule 5 means Schedule 5 is prevailing over subsection 3. Now you go to section Schedule 5. Schedule 5 has got three parts, part 1, part 2, part 3. Okay. Part 2 contains 5 sections. Section 1 speaks about a public company may pay remuneration in accordance with the limits laid down under 5% or 10% as laid down under section 197 of the Companies Act. So section 1 speaks about in accordance with the limits laid down under section 197 of the Companies Act. Then section 2 speaks about where there is no profit or inadequacy of profits, a company may pay the remuneration in accordance with the graded remuneration given below. Section A is there, section B is there. So section 2 is nothing but the continuation of the section 1, because section 2 starts where there is no profits, where there is an inadequacy of profits. Section 1 speaks about payment of remuneration by a public limited company in accordance with section 195. When section 1 applies to public company, section 2 is the continuation of the section 1. So section 2 shall have to be applied only to a public company. Then section 3 speaks about enhanced remuneration. Then section 4 speaks about regarding perquisites like provident fund, contributory provident fund, gratuity, etc. So section 5 speaks about when the managerial person draws remuneration from two companies, the highest of the remuneration in respect of one company only he has to draw. So the section 1, section 2, section 3, section 4, section 5 together if you read, you will be able to infer that part 2 itself applies only to a public company. When it applies to a public company, subject to provisions of Schedule 5 appearing in section 197(3) also applies only to the public company. By no stretch of imagination one can say that 197(3) applies to private also. One cannot conclude. That is the precise reason when the ministry has issued the exemption notification, it has exempted only the 196(4) from the private companies. It has not exempted 197(3). For the simple reason, you don't have that power. When you don't have that power, how will you exempt it? Okay, so that is the reason. Okay, that's one. Then, when you come to listed company and unlisted company, companies other than listed companies and subsidiary of a listed company may pay remuneration where there are no profits or inadequate profits beyond the limits specified in Schedule 5 without the approval of the central government. So one has to now read the rules and also the section 197. So companies other than the listed companies, other than the subsidiary of a listed company, if the remuneration is beyond Schedule 5, they can pay the remuneration after getting the approval of the general body, right? They need not go to the central government. Only thing, Rule 7, Sub-Rule 2 lays down certain conditions. What are all the conditions you will have to comply with? A company has to pass board resolution by nomination and remuneration committee. It should not list these unlisted companies, not defaulted in repayment of debts, including deposits, debentures or interest payable thereon, preference shares or dividend on preference shares for a continuous period of 30 days in preceding financial year before the date of payment to such managerial personnel. Special resolution by the shareholders have to be passed, and such a resolution for payment of remuneration shall not exceed 3 years. Notice of the general meeting shall contain a statement, the case explanatory statement, what are all the information it has to be given, that particular rule itself gives. Then the company should not have defaulted on the filing of balance sheet and annual return. If you are able to comply with this Rule 7.2, unlisted companies and unlisted public companies and subsidiary of an unlisted public company, they can pay the remuneration to its managerial personnel beyond Schedule 5 after getting the approval of the general body, and they need not go to the central government. Then, the company in general meeting may, with the approval of the central government, authorize the payment of remuneration exceeding 11% of net profits of the company, subject to provisions of Schedule 5, Section 197, Subsection 1 proviso. This read with Rule 7.2 makes clear that a listed company and a subsidiary of a listed company can pay remuneration beyond the limits specified in Schedule 5 only with the approval of the central government. So, unlisted companies after getting the general body approval, listed companies with the central government approval. Then, we have already seen remuneration to CEO, company secretary, CFO does not fall under remuneration to managerial personnel, though they are whole-time key managerial personnel. Then, the moment if there are no profits in a company or the profits are inadequate, Schedule 5 squarely applies. In case of listed company and a subsidiary of a listed company, at the threshold appointment, at the time of appointment itself, when the remuneration exceeds the Schedule 5, you have to get the prior approval of central government. That is how Section 197, Subsection 3 is worded. Where the managerial remuneration is beyond Schedule 5, the same can be made only with the prior approval of CG. 197, Subsection 11 deals with the increase in remuneration. It says if the increase is not in accordance with the Schedule 5, it can be made with the approval of the CG. You will not find the word prior approval in Section 197, Subsection 11. Whereas you will find the word prior approval in Section 197, Subsection 3. So, at the time of first appointment, at the time of appointment itself, when you seek to give remuneration beyond Schedule 5 to a managerial personnel, you will have to get prior approval. But you have appointed him and paid the remuneration within the limits of Schedule 5. During the continuance of employment, during the course of employment, if you seek to enhance his remuneration and that enhancement is beyond Schedule 5, then you can pay it only with the approval of central government. That approval can be post facto approval also. Then High Court of Judicature Rajasthan High Court of Judicature for Rajasthan versus PP Singh and another. This particular case law is rendered by Supreme Court in the context of the judicial appointments and the prohibition and excise superintendent AP and others versus Toddy Papers Cooperative Society, Maradepalli and others. This is also in the context of prohibition of liquors in the state of Andhra Pradesh. In these two judgments, the Supreme Court has said that unless the statute says prior approval, the approval can always be post facto approval also. Then 197 subsection 2 deals with the percentage of remuneration shall be exclusive of fees paid under section 197 subsection 5 sitting fees. Okay. 197 speaks about sitting fees. A director may be paid sitting fees for attending the meeting of the board or attending a committee of the board not exceeding rupees 1 lakh. And it also says there should be no discrimination in payment of sitting fees between a woman director, ordinary director and an independent director. Okay. And this sitting fees is exclusive of the managerial remuneration. This is a departure from the 1956 Act. 1956 Act, if you pay the sitting fees, it is also regarded as managerial remuneration. That is the precise reason, prior to the notification of the Schedule 13, in a company, if a managerial person was drawing sitting fees, if he is paid some other remuneration, then that some other remuneration is regarded as increase in remuneration. Invariably, they had to get approval under 310 of the Companies Act, under the old Act, okay, prior to introduction of Schedule 13. Okay. Then, then Ministry has also subsequently given clarification. You are paying sitting fees and also the additional remuneration. If these two put together within 5% of net profits, then it cannot be regarded as increase. Though it is regarded as increase in remuneration, you need not come to the central government for approval under the 1956 Act. Okay. Now, under the 1956 Act, since sitting fees was treated as part of the remuneration, and you know that under Rule 12B of the company's central government general rules and forms, a fee of 10,000 rupees has been fixed, if my memory is right. Okay. For increase in payment of sitting fees, you can approach the central government under the 1956 Act. Now, since the sitting fee is not regarded part of the managerial remuneration, first of all, you cannot increase the remuneration beyond 1 lakh. Okay. Even if you ask that whether I can go to central government for payment of sitting fees beyond 1 lakh, you can also not go to central government. So the sitting fees is restricted only up to the amount of rupees 1 lakh. Then we have already dealt, no discrimination can be made against one director, independent director, may be decided by the board. Then overall managerial remuneration under the 2013 Act, it shall not exceed 11% of net profits exclusive of sitting fees. Overall managerial remuneration shall not exceed 11% of net profits inclusive of sitting fees. Ministry has also given clarification under 1956 Act. If the remuneration is paid under the Schedule 13, then the managerial personnel cannot be paid the sitting fees. Okay. Now sitting fees can be paid to managerial personnel also. Then 2013 remuneration for one managerial personnel, it shall not exceed 5% of the net profits of the company. 197, if you read, we may be misled sometime. Okay. 197 it says, a managerial person in case of a single managerial personnel can be paid remuneration in excess of 5% with the approval of the general meeting. Then it raises a question whether he can be paid remuneration up to 5% without the approval of the general meeting, whether the board meeting alone is suffice. For that you have to go to 196.4. 196.4, a managerial person has to be appointed the board, his remuneration has to be fixed in the board meeting, and once again his appointment is approved in the general meeting and remuneration approved in the general meeting. So for up to 5%, you will get the approval under 196(4). Beyond 5% you will get the approval under 197. So that is the sum and substance. Okay. So with the approval of the, in case you have got only one managerial personnel, it shall not exceed 5% of the net profits. That has to be approved under 196 subsection 4. Beyond 5%, it can be approved under section 197, right? 197, with the approval of the general body, you can make the payment. You can make payment up to 11% of the net profits, inclusive of the other remuneration paid to the other directors, excluding the sitting fees. If the other directors are paid some remuneration, you can pay up to 11%. Beyond 11%, if you want to pay the remuneration, then you have to go to first schedule 5. Whether that individual remuneration beyond 11% fits in the table given in schedule 5. If it fits in the table given in schedule 5, then you can make payment of remuneration as per the schedule 5. If it goes beyond schedule 5 only, then you will have to go to the approval for the central government. So that is in case of listed company and subsidiary of a listed company. Unlisted company and subsidiary of an unlisted company, even if it goes beyond schedule 5, you will have to get the approval of the general body only, and now you need not go to the central government. So that is the sum and substance of payment of remuneration to single managerial personnel under the New Companies Act. Then payment of remuneration to more than one managerial personnel. Under the 1956 Act, payment of remuneration to more than one managerial personnel shall not exceed 10% of the net profits. Subject to that, it shall also not exceed 5% of net profits to a single managerial personnel. There is a leverage given under the 2013 Act. You can pay 3% to one person and 7% to another person. So where there is two managerial personnel, the overall managerial remuneration to the two managerial personnel shall not exceed 10% of the net profits. Okay. You can also exceed 10% and go up to 11% of the net profits with the approval of the general meeting. Once you go beyond 11%, you have to go to schedule 5 only once again. For those several managerial personnel, individually you see individual remuneration whether it falls within the schedule 5 of the Companies Act for each of the managerial personnel. For each of the managerial personnel, if it falls within schedule 5, then you can pay after getting the approval of the general body to those managerial personnel. If it is beyond schedule 5 only, in case of listed companies and subsidiary of listed company, you will have to go to the central government. In case of unlisted company and subsidiary of an unlisted company, you have to get the approval of the general meeting only. You need not go to the central government. That is the one. Then payment to ordinary directors may be paid a monthly remuneration or percentage of net profits and a combination of the same. Under the old Act, may be paid monthly, quarterly, annual payment with the approval of the CG or by way of commission by way of special resolution. Under the old Act, they can be paid, ordinary directors can be paid monthly, quarterly, annual remuneration after getting the approval, or by way of percentage of commission of net profits after getting the special resolution approval from the general body. Right? Under the old Act, beyond 1% or 3%, you can pay it provided you go to the central government and get the approval. Under the new Act, payment up to 1% or 3% can be made even without the approval of the general body. It is the board power. Unlike 196(4), up to 1% where you have got a managerial personnel, where it's a board managed company up to 3%, nowhere the Act speaks about you have to get the approval of the general body. So approval of the general body is contemplated under 197 only when it exceeds 1% or 3% as the case may be. Okay. So beyond the 1% and 3%, naturally you cannot look to schedule 5. Schedule 5 deals with the payment of individual remuneration to the managerial personnel and not to the ordinary directors. So the moment it crosses 1% or 3%, you will have to make an application to the central government only for payment of remuneration to ordinary directors. Then this is the decision of the Calcutta High Court in this particular case. National Engineering Industries Limited and another was the Secretary Ministry of Law Justice Company of New Delhi and others. Of course, this judgment is no more applicable to the 2013 Act. Under this judgment, Calcutta High Court has said sitting fee is part of the remuneration. If you opt to pay sitting fee remuneration over and above the sitting fee, then you have to take the approval of central government. So that is the one. This judgment is no more applicable. Then The remuneration payable to directors of a company, including any managing or whole-time director or manager, shall be determined in accordance with and subject to the provisions of this section, either by the articles of the company or by special resolution, or if the articles so required by special resolution passed by the company general meeting, and the remuneration payable to a director determined opposite shall be inclusive of the remuneration payable to him for the services rendered by him any other capacity. Okay. 197 subsection 4 is talks about payment of remuneration to a managerial personnel in respect of the services rendered by him any other capacity. It shall include also. This is more or less worded on the same lines of old section 309 subsection 1. 309 subsection 1 contained a proviso, provided where the services of professional nature, you have to get the opinion of the central government and it can be exempted. That is now given to, that power of the central government is now vested with nomination and remuneration committee. Remuneration for services rendered by any such director shall not include, if the opinion of the nomination, in the opinion of the nomination and remuneration committee, if the company is covered under section 178(1), that is where it has to appoint this committee, or the board where that committee is not applicable, nomination remuneration committee is not applicable, or in the opinion of the board, the director possesses the requisite qualification for the practice of the profession. So if he has given some services in relating to his professional capacity, that remuneration shall not be considered as a managerial remuneration, and earlier for that you have to make a reference to the central government. Now that power of the central government is vested with the nomination and remuneration committee, in case if the company is required to appoint such committee, if the company is not required to appoint such committee, then the power is vested with the board. If the board is of the opinion that particular person possesses the qualification for the practice of that profession, that remuneration given for him in that professional capacity can be excluded from the managerial remuneration. And Rule 6 of the Companies Meetings of Board and its Powers Rules 2014, every listed company, all public companies with a paid-up capital of 10 crore rupees or more, having turnover of rupees 100 crore or more, having in aggregate outstanding loans of borrowing or debentures of deposit exceeding 50 crore or more, shall have an audit committee and nomination remuneration committee. So this is the when you should have a nomination remuneration committee. So if you have this committee, then you have to take the opinion from that committee that particular person possesses the professional qualification for practicing that profession. Then this particular case law has been rendered in context of guarantee commission. A company has paid a director to a guarantee commission. Matter ministry has launched prosecution. Matter went to the court. Court said guarantee commission cannot be construed as a commission paid in any other professional capacity, because for giving guarantee commission, that director pledges his credit worthiness. Like in case we have deposited some money with the company, right, he may be earning interest on it. That interest cannot be regarded as a remuneration in any other professional capacity. Likewise, guarantee commission, instead of depositing it, he has pledged his credit worthiness with the bankers, for which the company has paid him the guarantee commission. That guarantee commission cannot be considered as remuneration in professional capacity. Then, subject to the provisions of this section, a managing director or whole-time director of a company who is in receipt of any commission from the company can receive any remuneration or commission from any holding company or a subsidiary company, subject to its disclosure by the company in board's report. So he can also draw remuneration. A person, whole-time director, who draws commission from the company, he can also draw remuneration from any other holding company or subject company, subject to the disclosure. I mean, this is not a very big helpful to the company, because under Schedule 5, because the moment if Schedule 5, Section 1 also speaks about payment of remuneration within the limits laid down under the Companies Act. If you see Section 1, subject to the provisions of Section 196, a managerial personnel can be paid 5% or 10% of the net profits. That is when the company is having the profits. Okay. Section 2 only operates where the company is having inadequate profits or no profits. A question may arise. A person is a managing director in A company as well as in B company. Okay. Both the companies are profit earning companies. In both the companies, I am paying the 5% of the net profits only. Whether I can pay that remuneration not exceeding 5% in both the companies. You can't do that, because Section 5 will apply for a company where there is a profit also, because Schedule 5 includes Section 1 also. Section 1 speaks about payment of remuneration 5% or 10% when the company is earning profits. Section 5 says where a managerial person takes more remuneration from more than one company, then he has to limit his remuneration to the highest of the remuneration in any one of those companies, and that remuneration he may draw from one or more companies. Okay. So even in a profit making company also, where a managerial personnel is in MD in two companies, where those two companies are profit making companies, because of this Section 5, he has to still take the remuneration, highest remuneration of one company only. He cannot draw 5% from each company. So 197.4 is not much helpful, I want to say that, because of the Section 5 of Schedule 5. Then independent director remuneration, it says independent director shall not be entitled to receive any stock option. He is entitled to receive sitting fees and reimbursement of expenses for participation in board and other meetings. He can also be paid profit related commission with the approval of the members, that is that 1%. Then insurance for indemnification. Under Section 197 New Act, insurance for indemnification of the director has not been made void, whereas under the 1956 Act, any indemnification of the director has been rendered to be void under Section 201, subsection 1 of the old Act 1956. And because it is not made void under the 2013 Act, the premium paid for taking any policy for indemnification of a director shall not be treated as part of the remuneration. But there is one rider. If the managerial personnel is prosecuted and if he is held guilty for any of the acts under the Companies Act, then the premium paid for his policy will be regarded as remuneration. If he is acquitted, if he is not held guilty, then the premium will not be regarded as remuneration. If he is held guilty, then the premium will be regarded as remuneration. Over, finish. Another 2 minutes. Okay. Then, so when a company is deemed to be inadequacy of profits, 5% or 10%, the moment it exceeds 5% or 10% of the managed remuneration, it is deemed to be inadequacy of the profits. Ministry has given circular under the 1956 Act. The same circular will apply also. Now, with that I have broadly covered the Schedule 5 also. Only thing, Schedule 5 I have prescribed in detail, which I need not go through it now because shortage of time. With this I conclude. Thank you very much. Yes, please.
As the situation stands,
Pardon?
As the situation stands, there is no restriction of payment of remuneration to managerial persons of a private limited company. Is it so?
I can't understand you, please.
Now, if the directors of a private limited company is to be paid remuneration, is there any statutory limitation?
No limitation at all.
It can be paid subject to board resolution.
Yes.
As regards relative of directors.
But as on date, since the exemption notification has not come, you have to get the approval of the members. If the exemption notification is issued in future, then the board itself can decide.
There is a circular that relative of a director can be paid remuneration of Rs 2,50,000 per month. Is that circular today holds good?
That holds to private limited companies also.
And public also? Relative of a director in case of public limited company?
That you can pay up to 2,50,000.
That only.
The moment it exceeds, you will have to get the special resolution from the general body.
Okay, thanks.
Yes.
Regarding appointment of independent directors, is it applicable for the private limited company?
Private limited company it does not apply.
And it is not compulsory?
It's not applicable.
And what about women directors?
Women director also private limited company not applicable. In the rule it says only the public company also. Only public company in the rule.
No. There is only one ordinary director. Whether the retirement by rotation will apply?
There is only
One ordinary director.
only one ordinary director.
Yeah, remaining are independent directors and whole-time directors.
I can't understand. One director can be there only for one person company.
No, there are 5 directors. One is whole-time director, 3 are independent directors, and 1 is ordinary director.
Okay, you whether it's a public it should be a public company.
Unlisted company.
Unlisted public company.
Yeah.
For the purpose of rotation of director, your total number of directors is 5. Okay. In that you have to exclude the 3 directors. Right? Then there is only 2 directors remaining. In the 2 directors only you will have to calculate who are liable to retire by rotation. Okay. One will retire by rotation, one will remain there. Thank you very much.
Thank you, Mr. A.M. Sridharan, for simplifying the various provisions pertaining to directors and managerial remuneration. On behalf of the Bangalore branch, I wholeheartedly thank you once again, sir. Can I now request the conference coordinator, Mr. Ravi Prasad, to kindly present a memento as a token of our gratitude.